Okay, good morning, everyone on Facebook. We are live. I hope that the holiday went well for you and that you were fulfilled with love and joy and time you spent with your loved ones. And obviously, the holiday shopping season is upon us. And we thought that this would be a great time to honor small businesses on Small Business Saturday with our launching our first video Q&A series. So I want to first introduce ourselves. My law partner, I'll let her go first.
Hello, everyone. I'm Elon Moore Jones. I am an attorney managing partner at the Elaine Law Group, and I'm excited to have this opportunity to share our knowledge, impart some small gems to help demystify the trademark or business law phase for our small businesses in our community. Our goal has always been to service the community as best we can. So providing these free forums are one start for that. So I'm happy to be here and excited to answer any questions and also just to give general information.
Awesome. Thank you, Elon. And you could probably imagine the E in Elaine Law comes from Elon Moore Jones, attorney. My name is Lorraine Birabil. I'm also a co-founder and partner at this firm, Elaine Law Group. The AINE, that's me, Lorraine. Together we form Elaine Law. But we are very happy to be able to serve you in terms of what we focus on. Our goal is to elevate your dreams, help establish your brand, and expand your legacy. We're client-centered. We serve creative professionals and entrepreneurs, and we look to develop a meaningful relationship with you and be a part of your journey in developing your creative or entrepreneurial dreams and successes along the way. So with that being said, let's go ahead and jump right into it. So now that you have an idea of who we are here to work relentlessly to help you accomplish your dreams and bring them within reach. Let's talk a little bit about what we do. Alon?
Yeah, so we offer wraparound services pretty much for small businesses. I like to consider them as holistic because we try to provide as much service as possible to our small business owners. That being said, we obviously provide trademark services that will be applying for your application, answering any office actions, as well as some have petitions to counsel others existing trademarks or applications. We've also filed some petitions to cease a few applications, and we're just happy to help with that process. Trademarking can be daunting, so trademark is one of our top practice areas. We also provide copyright support and application filing for any copywriting. Sometimes trademark is not the route for you. So we provide a trademark opportunity and venue for that. We also provide general business legal support and contract formations, operating agreements, as well as NDAs, some of your basic business law one-on-one items that you need, just launching items that you need for continuing your business, those contracts, those agreements, and the like. In our practice, we also provide some estate planning and some basic estate planning needs with your wills. If you have your trademark, if you have your copyright, you also want to be able to leave that legacy to your family. And so we want to be able to provide that to you as well with some estate planning. We also, in having your trademark and your copyright, we want usually those items to be under your business entity. So with a lot of our small businesses, we need support with business formation, getting that actual LLC, changing your DBA to an actual LLC, and protecting you more effectively against any personal liabilities. Also, a lot of our business owners have found that their LLC has been forfeited. So we also support with reinstating your business entity with the state of Texas. We also do business formation filing in any of the 50 states. So.
And I do want to highlight, when you come to us, we're going to help you come up with a customized strategy based on the industry that you're in and your needs you are. Perhaps you're in a highly regulated industry. Perhaps the industry that you work in requires a corporation. Perhaps you have investors that you're looking on taking on. Maybe you might need an investor agreement. Perhaps you need an operating agreement because there's more than one owner of the business and you want to define the scope of responsibilities and how decisions will be made. Perhaps you're also thinking to the future of business continuity. Who will take over the business? Because it's not a question of if something will happen to us or if we will pass on. The question is really when, right? And no one knows the time, the day, nor the hour. And so part of being a responsible business owner, part of being a responsible person who is owning the creative material that you've made and worked so hard to do is making sure that it's left in the hands and managed by those that you think are most suited to protect it. And so just to sort of piggyback on what my partner was bringing up, sometimes creatives and entrepreneurs come to us and they're not really sure exactly what they need. Even if you don't know exactly what you need, we can provide you a one-on-one service where we talk through your particular situation, your particular needs, and come up with a comprehensive game plan on protecting your dreams, whether it's something that you made that's a creative work or a business that you are building or have already built. So those are the short version of it. We also have several attorneys we work with of counsel at our firm. For example, if you happen to have an immigration issue that you're dealing with, there are lots of business owners who are in that circumstance. We can definitely work with you. We have enough counsel attorney that specializes in that, as well as tax. Let's say, and Alon did bring this up earlier, but that extends not only to state tax, but also federal tax. If you have a tax controversy, we do have an of counsel who's a CPA with our firm that can answer questions on those issues and work with you to navigate that properly. So, and short version is, we serve entrepreneurs and creatives. That's who we focus our time and attention on, and their needs can be wide and varied. So at this time, now that you have an idea of who we are and who we serve and what kind of work we do, I think we should go ahead and get to the business of today, which is Small Business Saturday. Some of the questions that we often get are around trademarks. It's one of the best ways that you can protect your brand. And so, Alon, if you want to talk about, what is a trademark? Because some people often confuse that with a copyright and they're not really sure what the difference is and what protections each offer.
Yeah, so a trademark is your federal registration. It's that R with the circle. It's not the TM, which most people often use mistakenly and erroneously. People also use the R circle as well with the idea of wanting to be a registered mark, but not actually being a federally registered mark. You actually should not be using that encircled R unless you do have an actual federal registration. A federal registration, as I could show one of our clients registered registrations. This is what the actual certificate looks like, obviously covering up the address for privacy reasons, but a certificate comes from the United States of America Patent and Trademark Office. And that certificate is the only reason you should be using that encircled R in relation to your mark. Your mark also, as far as trademarking goes, your mark also can be registered in certain categories and should only be used in association with the category in which you are actually registered. For instance, t-shirts, hats, and sweatshirts, that's one category. Whereas a filing cabinet, which is behind me, is a totally different category. For obvious reasons, we utilize them in our everyday lives in different purposes and in different ways. So you don't use a beverage, you don't think of a beverage like Coca-Cola in association with the file cabinet, right? You might have cola filing cabinets and they're completely protected and okay. And using that mark, which is a federally registered mark, not to say the Coca-Cola won't come after you, because they will, but it's just for lack of a better example, people, the general public, will not confuse the beverage Coca-Cola with a filing cabinet company. So that's furniture and things of that nature, storage furniture, things of that nature. So that's in a very, very tiny nutshell. That's the gist of trademark law. It's a federal registration. It gives you the right to sue anyone who infringes. It gives you the right to, or power behind your cease and desist. Most people think that they can send just a cease and desist and that's it. But when you have that cease and desist and it literally says, I own the registration mark number, da, 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 and you are now in violation of infringing my federally protected registration, you can then take them into court if they fail to cease and desist any infringing activities. So that's trademark. Now, copyright, I'm sorry, and trademark also it is housed or managed by trademarks, and patents are managed by the United States Patent and Trademark Office. And so that's uspto.gov. They house any trademarks and patents. Whereas copyrights are like the counterpart to a trademark. However, most people think of copyrights when they think of books, right? Every book, for the most part, has been copywritten. A lot of people think of the poor man's copyright when you can mail something to yourself. It has a US postage mark on it, and you think you're protected. However, that has been a long done away with idea. It's not a protection. It will merely show that you have used something maybe in advance of someone else's, but it does not give you the federal protection that a copyright will provide to you when, say, your artwork, your photographs, your books, your logos, choreography can be copywritten. So a very narrow scope of items can be copywritten, and those items will have to actually fit into those categories and actually allow for something like, if you did choreography, even though it is like a service, you can actually copyright each movement in its particular in the particular way in which you have presented it to the general public. It would also need to be something that is captured in a moment in time. So capturing something like that choreography in a video, capturing your written words in a book, capturing your written words in, say, a video blog or a online blog. Those items can be copywritten. Whereas trademarking, we think mostly of things like goods and services. Goods being a water bottle, something tangible you can actually hold. A service being something like our legal services, something that you provide, like coaching, wellness coaching, business coaching and the like. Those are services that you provide to people, whereas goods are actually tangible.
Thank you for providing that clarity, Alon. I just want to piggyback on some things, if that's all right. Uh, when we think about trademarks, one of the biggest part of it is brand protection, right? And we've heard stories, I don't know how many of you, I know some people will be in North Texas, which is where I am based, and people will be in Houston, where my law partner is based. But for example, there's a very well-known pizza shop in Dallas named Blackjack Pizza, and I've been going to Miss Dorothy for everything that's good there, and that's what she says. You go to Blackjack, and she says, "Baby, everything is good." And let me tell you, I've tried everything, and everything is good. But she operates a mom and pop pizza shop. And unfortunately, it was in the news a few years ago that a pizza chain with a similar name in Colorado, sought legal action against her for the name that she had been operating under for decades. And so part of the reason why you want to get a trademark is to protect your brand and your business name. It's just like people say about you as a person, right? You want to protect your good name. It's the same thing with your business name. Having a trademark helps you protect your name. In many ways, you've worked really hard to build up a certain level of respectability and in the marketplace, a product, a brand that people expect a certain level of quality from, whether it is a service or a product. And so you run the risk by not securing your name that one day you might get a cease and desist letter. And that is not something that we want. And particularly a lot of businesses in our community, just because of for a lack of not knowing, may find themselves in that situation. So part of wanting to get a trademark is not just to protect your business name and to own it as an asset of the business. And if you watch Shark Tank, they always ask you, do you own any intellectual property? That's what they're talking about. Do you own a trademark? Do you own any copyrights? Do you own a patent? A patent is something that you can invent and can be produced for a certain amount of time under that trademark through licensing agreements. And you can license copyrights and you can license trademarks. And so they are all assets for your business. But it's also about defending your business, right? And as Alon brought up, if someone else is using your business name without your consent, or your brand that you're building without your consent, you then have a very strong cease and desist letter that you can use against anyone who's using a name that is confusingly similar if it is a trademark. And so there's definitely protections that come with that you want to utilize, but also it's a protection against you so that you're not unfortunately put out of business unnecessarily because you didn't get the proper registration. And so
forced to rebrand at a time in which you had no intentions on spending that type of money to rebrand your image, your company, or your products.
Absolutely. And you can imagine, the cost that can be involved with rebranding, particularly if you might happen to have an inventory, for example, and everything has this branding that you're not allowed to use anymore, right? So definitely it's something that every business owner needs if they want to not only make their name or their brand a business asset, but also to protect them from liability, because there are obviously innumerable businesses that are operating in various industries. And so cannot overstate how important that is. It's a federal registration. And it not only protects against identical marks, but those that are confusingly similar to your mark. It provides a nationwide notice that you are the owner of that intellectual property, and it's protected throughout the entire country. And as Alon brought up, it gives you the right to use that circle R that you see there.
As well as worldwide. I would also add that, most foreign countries want to receive the US trademark registered mark and registration protection. So our database, USPTO's trademark database. It's also used and accessed worldwide to compare and contrast whether or not there's any possible infringement from anyone attempting to register a copyright either in Europe or the EU, India, and the like. So.
Thank you for bringing that up, Alon, because we are in an increasingly global marketplace. And anywhere that you are online, that means you can reach anywhere in the world. And the United States is a party to to treaties that do protect intellectual property internationally. We do have a question online from Melanie. Hi, Melanie.
Hi, Melanie.
I want to make sure we get to your question while you're here. She asked, how can I properly check if my business name is truly free for me to use?
Okay, yeah, great question. Do you want to tackle that one or you want me to take it?
You can go ahead, Alon, because I'm also monitoring the Facebook because I just want, we don't want to miss anybody through Messenger or through the chat.
Yeah, so Melanie, thank you for asking. What happens with our trademark and research process is that we investigate, do a thorough knockout search, and that search covers the USPTO's database. It also covers anything on the World Wide Web, as well as any items that or names that have been registered within the continental United States and any of our provinces or territories. So what we provide as a service is the initial phase of our trademark search. And that is the knockout research. And that research, again, gives you some idea whether or not anything similarly confusing or something that could pose as a potential threat to your business name, whether or not it's out there. What I like to add as well to the answer to this question is that a lot of our small business owners are DIYers, and there's absolutely nothing wrong with that. But what you find is that you may not know how to, or you may not have the resources to do the deep dive and thorough investigation that's required in order to really, really determine whether or not you're infringing or if someone else is infringing upon your name or the name that you like to use. With that includes anything closely related to the services or goods that you're providing, or anything directly alike or aligned to what the services you're providing. For example, if you are providing fitness training or dance choreography, something closely and similarly related would be fitness apparel, because most fitness companies have an apparel, or most choreographers have some type of apparel or similar item that goes along with their services that they're providing. If you're doing fitness, maybe someone may have done more of a narrow registration for something like yoga. Well, fitness and yoga are one and the same. They're in the same category. So those are things that we look for in our research for you as a client when you sign on. Those are things that you need to look for if you're a DIYer, a do-it-yourselfer. But what we find most often is that a lot of our clients are DIYers. They've probably already been using the names. And then we find that, well, you've been infringing on this particular registration. It's been registered since 95. But again, I'm going to pause there because that'll lead me into something that we'll cover a little bit down the line, because there are a lot of marks out there that have been registered for a very long time, but we find that they're no longer using them or never used them to begin with.
And that is something new with the trademark office. And obviously, as experts in the space, we're always keeping up to date on the latest and greatest and newest developments in this space. I want to get to another question we have. We have a question from Julia. She asked, can you modify a registered mark?
Is federally registered mark a trademark?
I I assume so, Julia. When we talk about marks, and I don't know, she didn't ask this, but I'm just going to throw this out here. And it was mentioned earlier, but I just want to make sure we cut, in case you missed that part. The TM does not mean that there's a federal registration. The Circle R means it's a federally registered mark, and you only have the right to use it if it's federally registered. So it is possible to have a common law trademark. It is possible to have a state registered trademark, but neither of those provide you the level of protection that a federal registered trademark does. It essentially is a prima facie proof that you own that intellectual property. And also the added benefit to it is it takes away the good faith defense for the infringer. So let's say, for example, the person says, well, I didn't know that ABC company had trademarked XYZ brand, right? It takes away that good faith defense so that even if they say that that's a defense, they're still responsible, they're still infringing. And so let's, from a federal standpoint, Alani, if you can speak to how we modify a registered mark.
Yeah, so for the most part, when you already have a classification in which your mark is registered, and I'm assuming that may be where Julia's question is coming from, maybe you already have a classification in which your mark is registered. For example, your mark may have been registered for an online blog, a non-downloadable media presented to the world on the World Wide Web or something like that, right? Online blog, and your name may have been like free fashion advice, very generic, but free fashion advice Tuesdays online blog. Now you want to move into providing some apparel or some products, some goods or whatever. So now you want to move into a new line of sweatshirts to go along with your online blog because people always want to buy merchandise, right? Well, your registration was for the blog. Now you want to register for your sweatshirts. Hope you following me, Julia. Wish I could see you and get a head nod or no. But in order to now move into that category with that registered mark, you do have to file and apply for a new registration. Because simply there are different categories. The PTO charges per classification. It's got an international classification. We call them ICs for shorts. So shirts are in IC 25. Online blogs, I'm probably wrong on this, maybe like 41, right? Or online social media presence and things like that is 41, right? You are not able to cross registrations. Like, okay, I have this one, I get to now move and go and do this one. It stands on its own. It's like, what were you saying? Law school, every tub has to stand on its own feet. Or on its own bottom. Your request to have a registered mark for a t-shirt or sweatshirt now has to become its own application and has to be applied for separately. It would be the same as if you did it all at one time. Each classification would call for a new fee. The PTO charges per classification. That's $350 or $375, depending on the type of application, per classification. So Julia, if you can say yes or no, whether or not that answers your question, that'd be wonderful. I hope it did. But for the most part on the trademark, no, you do have to apply again. And I mean, we think of it, we have to think of it as the federal government. The federal government has an interest in, protecting intellectual property, but also allowing for the free flow of intellect and of innovation. That is the purpose of the PTO. You want to make sure that people don't try to monopolize a particular mark, right? You can't just hog and boss hog everybody out of the market when you're not using it at that time, or just because you had it in one category, now you should get it in the other. No, everybody has to go through the same process for each classification. Did Julia? And did that answer her question?
I think she said I am to, she's referring to a federal trademark. I think that's what that response was for. And the piggyback on, and Julia has a couple more questions, and I think I can, it seems like we're having a little lull in questions, so I think I can take this question without being worried that we're missing somebody. But I want to make sure we answer all of Julia's questions. She said, is it better to register a logo or a name if your logo is part of the name? Thank you, Julia. This is a very common question that we get. So for example, we typically recommend that, it is mission critical, right? That you own your name, right? And just like the example we brought up earlier, if you don't own your name, there definitely could be legal consequences for using it in the marketplace without having the registration, right? And so, yes, you definitely want to make sure that you own your name. And so if you are in a position where your budget, you're a growing emerging business, and we serve a lot of emerging businesses, may not allow to register for both of the marks right away, you definitely want to register your name first. And the reason why we suggest that is because one, it does allow you to first and foremost secure the name, and two, by trademarking the name, no matter how you rebrand, right, you will still own your name. And sometimes businesses do rebrand. They go through various iterations of how they market themselves visually. And so if you're in a position where right away you only have resources for one or the other, definitely want to register your name first. Obviously, you definitely want to register your logo, at the first available opportunity, because that is also how you're marketing yourself. You're marketing yourself under your business name and visually how you represent yourself. And so definitely want to trademark your logo as well as brand protection. But if you can only do one at a given time, you definitely want to start with the name of your business first. And to Julia's question, what if the logo name is part of the logo, or whether it's not a part of the logo? If you register your logo and you don't register your name, guess what? You still don't own your name, even if your name of your company or your brand is inside your logo. The USPTO still considers them two separate registrations for protection purposes under the Lanham Act. So with that being said, even if the name of your company is in your logo, you still don't get a 2-for-1, unfortunately. You still want and still need, frankly, to have both registrations done. And then, so I hope that answered your question, Julia. And then there's another.
Oh, we have another question.
Oh, no. Go ahead, Alon.
Okay. Only thing I would add there, Lorraine, is that you got to think of the logo, Julia, or anyone else that's inquiring minds. The logo is fixed. It's a fixed item. And you are only entitled to the registration of that mark as it is used within that logo. For example, if you want to put your company name in a sentence, that's kind of like the best example that I try to give to everyone. You can put your company name in a sentence in association with, say, your website. In association, maybe you are having a brochure printed and put out or things like that. It is, you're not going to put your logo in the sentence of your brochure, most likely. Most people aren't adding an image in the sentence structure when you're describing, say, your mark. Most people's logo is only fixed in the upper left or right corner of their website, but not throughout. So anybody can take that name out of that logo, say it's Julia's Fine Jewelry, and they can go and use it however they like, because your logo is just fixed. It is fixed in that structure, that imaging. So whether the words are there or not, think of it, I like to think of it that way.
Thank you, Alon. That's really a great example. Julia, I believe, has one more question. Alon, if you can take this, how long does the entire process take? And when can you use the circle R for registration?
I'll start with the latter question. We mentioned the registration certificate that you'll receive from the PTO. You'll get also a notification if you use our services from us as well as from the PTO as to whether or not the mark has finally received registration status. Once it has received registration status, then and only then should you use the encircled R in association with your mark. As of late, we all know for the last 2 years, our life has been COVID. So COVID has definitely delayed the trademarking process. I just from experience, the last few marks that we've done, we have gotten responses at about the 8-month mark from being assigned an actual examining attorney. The examining attorney is the person that reviews your application and is assigned a mark from the PTO. This 8 months does not include our research, our consultations with you. It does not include any adverse items that we may have run into in the research process and maybe requires you going back to the drawing board and things like that. That is the 8 months from submission of application to the PTO assigning it to an examining attorney and reviewing it. That's at about the 8-month mark. This is COVID, what is happening in COVID. And I honestly don't see it getting any better anytime soon because I don't know if people have been watching the news, but there has been a significant uptick in the amount of trademark applications that have gone into the USPTO, which includes reasoning behind the Modernization Act, which we'll discuss a little bit later. So what used to take 5 to 6 months is now taking about an additional 2 to 3 months. I one registration and you saw earlier went from January of last year to this month, literally. So that is, November 9th. And I literally filed that application January 1 or January, right before January 1, because that was when the increase on the application fees went up. So we were trying to get her application in before they did that increase. I believe that one was it. And so that's what, 11 months, almost 12 months. So from end to end, it can take anywhere from 8 to 12 months. If there's a question, an office action, which we kind of touched on earlier, that's after an examining attorney has reviewed your application, may have some questions. Your application may require now a disclaimer for a word that's generally used within the category that you've selected. A disclaimer needs to be responded to within the 6-month period, but that's the 6-month period is now going down to 3-month period. That's a part of the Modernization Act, which requires immediate attention and review. Otherwise, your mark can be forfeited if we do not. If you're a DIYer and you did not respond to those office actions in time, your mark can be forfeited. So office actions can extend the time period. What else could extend? Most things come in the form of office actions. Some examining attorneys are really nice. They send an email, say, hey, just respond to this email. And then we just respond to the email. Other examining attorneys wanted to go through the formal process and you actually have to submit a response through the TTAB. So.
And to piggyback on some of what Alon covered, essentially the office action is essentially litigation by paper or pleading, right? As licensed attorneys who practice in this space, we're legally qualified to go and argue for your trademark on your behalf with the U.S. Patent and Trademark Office. Another issue I want to highlight, and I'm sorry I failed to mention this earlier when we talked about the fees. This is me bringing my federal experience into this. But the USPTO is one of the few agencies that is self-funding in the sense that their operations are funded by the fees, the filing fees. And so pretty much almost everything that needs to be done, there's a fee for it. Certainly not across the board, certainly not literally every single, minute item, right? But most things, the vast majority with the USPTO, there is going to be some sort of filing fee that is required because it's an agency that is essentially self-funding. Even though they are in an annual budget with the federal government, they're designed to be self-funding in terms of their operations. The other thing I want to highlight, to the point that Alon brought up in terms of answering Julia's question on how much time it takes, I also want to highlight the fact that your protection starts from the filing date. So let's say, it takes us 11 months to, which is pretty standard these days, to get a trademark. It could be less, it could be more time, right? But let's just say, whatever the length ends up being, it is several months at least. Your protection date from infringement starts from the date of filing. So let's say, for example, you filed December 1. You get your trademark September, October next year. Someone infringes upon you while you're in the application process. Well, once your trademark is registered, your protection date starts from December 1. And that is very important. And that is the reason why we really try to encourage clients to get it registered as soon as possible. Because if somebody infringes you before you file your application, you don't really have as much legal protection to stand on, frankly, to try to do something about that infringement. And so that is a very important point that I just want to make sure that's clear to everybody. Yes, it can take several months to get it. There's a lot of trademarks are quite labor intensive to secure, but it is a worthwhile investment in your business, and the protection starts from the filing date. And so I just want to make sure that's not lost. I see Miss Vera is online. Hi, Miss Vera. Hope your morning is going great. Thank you for joining us. I see Melanie here has another question. How do you handle purchasing a domain name from someone, one that they have not used in years? That is a great question, Melanie. And I think Alana and I can both chime in on this one as well. In terms of the domain name, so when you own a trademark, let's say, for example, there are various, obviously we're on Facebook right now, which is a social media platform. There's other platforms like Instagram, Twitter, what have you, Foursquare. I don't know if anybody uses that, Pinterest, what have you. There's so many, right? But the point that I'm making is there is a law called the DMCA, which applies to copyrights, Digital Millennium Copyright Act. And we'll do another workshop on copyright specifically. I don't want to go too far down that path. But the long and short of it is, if you have a registered copyright and somebody appears to be infringing that, you can use the DMCA, which is a federal law, to require them to take down that content to protect you. Now, why do I bring this up? Because we're talking about trademarks today, right? The reason why I bring this up is because some platforms like Facebook, like Instagram, and others, they sometimes will apply the same standard the DMCA does with with copyrights to trademarks. So for example, let's say somebody on IG is using your registered trademark as their handle, right? We have seen instances where the platform has made the decision to disallow that user from using that handle, right? And so how does this apply to domain registration? Some providers will take that registration to mean that that person should not be able to have that. Some other registrants will say, well, you didn't buy the domain name, negotiate that with the owner of that domain name. And there are trolls out there who will, monitor trademark registrations and then go secure the domain name and use that as a way of being profitable, right? And so, when you have your one-on-one with us, if you decide to engage us to help you with this process, that is something we definitely cover in terms of, not just your registration so that you're legally registered, right? But then protecting your brand overall, as you're on social media, as you are online, as you're marketing your business and all the different channels that you will likely market it in, right? And that is one of the things that we definitely do advise on. Alon, would you like to chime in on that?
Yeah, the only thing I'll add is to interface with any of these social media platforms, even online sales platforms like Amazon, um, Alibaba, um, um, Etsy, what have you, Instagram, Facebook, you have to have a registered status in order to really even begin the conversation there. So it's important to understand the power behind federally registered trademark, as well as the power behind a federally registered copyright, in order to show the force of power, is required to just have a basic introductory conversation. You can send all the letters, all of the requests you'd like. But if you do not own the rights to it by having that federally registered mark or federally registered copyright, you haven't even gotten in the race. So just to think of it in that sense, you can all day, people will sit on those websites, but that's also a part of our registration research that we offer. We do search for any similar or infringing websites that are out there. So.
And Alon is bringing up a great point. You always, as a business owner, want to come from a position of strength. And even if you're in a situation where you have to negotiate with someone, having that registration puts you in a much stronger negotiating position than not having it, right? And so, that is, I hope, Melanie, we've answered your question on that. And I see, hi, Chriselle. Thank you.
Hey,
One of
Michelle.
our clients. Thank you for joining us. And thank you. She said, amazing information. Thank you. We're always glad to be helpful to the community and inform. Because we, again, we're doing this in honor of Small Business Saturdays. We really want to ensure that small businesses are in the best position possible to succeed. We know that small businesses really are the drivers of the economy. They are among the largest employers collectively in this country. And frankly, we didn't even talk about this, but a lot of people also have side businesses, side hustles. People work daytime jobs and have a side business. Just because something is a side business or a side hustle doesn't mean that one day you don't want it to be your main hustle. Doesn't mean that one day you won't earn enough to quit your day job and focus full time on that business. But if your side hustle is not protected, it's going to be really hard for you to make that leap, without having the proper protections in place. Because otherwise, the rug could get ripped from beneath you, and nobody wants that. So I do want to highlight that for sure. Melanie said, yes, we answered her question. So wonderful. Thank you so much, Melanie. Well, I want to go ahead and I know we're at 10:50, so we've been online for quite some time answering questions. Alon, do you want to bring up the Modernization Act and some of the recent changes?
Yeah, so just to circle back to our special that we have going now, I just want to kind of enforce the or solidify or fortify the reason or the importance behind having the proper legal representation. The Trademark Modernization Act goes into effect on December 18th, 2021. That is next month. Certain things are going to be delayed until 2022, like the 3-month time period in order to respond to office actions. It's important to know that you need proper legal representation. Even the United States Patent and Trademark Office highly recommends the representation of an attorney when filing your trademark applications or just attempting to receive any advice regarding your trademarks. simply because, this is our wheelhouse. This is our go-to. Just like you as a small business owner or a large business owner or an emerging business owner, you have your specialty, your wheelhouse. We have ours. We are small business owners as well. So we speak from an angle of understanding, right? We know exactly where you are, what it requires to keep day to day, 24 hours, 24/7 business going. The work of a small business owner doesn't end. But our job is to be your backing, your legal advice. You can call us with any questions. We can have constant or as many consultations are required or recap meetings that are needed to help you through the trademark process. The Modernization Act is sometimes help it in one instance helping you as a potential trademark owner, and in the on the other hand it's also uh I wouldn't say well, it's it is kind of complicating the application process in that it requires a more prompt and quicker response time than it used to. In December 2022, there will be a 3-month time period to reply to any office actions, whereas it used to be a 6-month time period. That 6-month time frame is being cut in half. People I have seen come to us, ask us 1,000 times over, hey, I had an office action, I forgot all about it. I'm now in month 8. What can we do? Well, unfortunately, there's nothing that we can do. We can petition, we can request, we can ask the PTO to reconsider or reinstate your trademark, but they're not obligated to do so once you've exceeded that 6-month time frame. Well, that 6-month time frame is now being cut down to a 3-month time frame. 3 months goes by in the blink of an eye. Okay. I can tell because I'm getting older as the days go by. And so does the office action. We think 3 months, so I have time, I can put this to the side. But as your attorneys representing you, it is our job, our duty to you as a client to make sure that we are filing things on time and as quickly and as efficiently as possible. So that's one hurdle that we're here to help you get over. Then there's also an opportunity in this Modernization Act to do proceedings called expungement. The expungement would be a party's opportunity to request the cancellation of any goods or services in a registration because that registered mark was never used in the trademark in commerce. In commerce means in exchange for money or the ability for people to purchase your federally registered mark item that is protected under federal registration. So what we're speaking of in that instance is that you have a lot of trademark pirates out here, particularly overseas. That's not to say that U.S. Companies do not do this because they do. They'll sit on a mark, say, I'm going to register my mark in all of these 30 categories. We advise totally against that because it just complicates things for you in the future and it's just unethical, honestly, if you're not using it in all of those categories. Okay, so you have hats, t-shirts, jackets, but you haven't even gotten to the jacket phase because you haven't gotten your contractor together. You don't even know what the item is going to be, but you've somehow circumvented and gotten the registration through the PTO for those jackets. Well, someone else along later down the line wants to maybe use that same or similar trademark for their brand, and they're being boxed out of that market because you are holding on or sitting on a registration for jackets that you never launched. So what the PTO is giving clients the opportunity to now do is to contest those for cancellation, and it's called expungement. That would have to happen between the 3-year or the 10-year mark for those that you're petitioning to be expunged. That's the same concept like what Melanie was asking about earlier about websites. People sit on websites and they want to like extort you for money in order to purchase it. Well, what the PTO is now offering is a venue, and it's a lot easier through this Modernization Act to get or protest for the expungement of someone that is not using the mark. Any questions, Lorraine?
I think we probably have received our last question. At this point, I just want to bring up a very special limited time offer that we have going on right now. And I'm not sure if you've seen on our Facebook, but we're offering this in honor of Small Business Saturday, because we know that, especially with this pandemic, right, a lot of small businesses have really gone through the trenches. And so we wanted to offer a very unique special to small business owners who are watching or monitoring our social media online, who have been thinking, I really need to get a trademark. I just don't know if I have this, sum to hand over right away in one lump sum. Well, guess what? We have something special for you. So we are offering, and again, in honor of Small Business Saturday, the Small Business Saturday payment plan. So if you are considering or want to go ahead and take that step to protect your business, to protect yourself from liability, to make your business name a business asset, this is the opportunity for you. Instead of having to pay the lump sum that will be typically required to register a trademark, we can work with you with a payment plan. We have a program now where you can make 6 payments of $500 a month. And what's included with that? This is a marquee package that we're offering. And Alon mentioned this earlier, one-on-one consultations. We are very hands-on with our clients because we want to make sure that it's successful, right? We don't succeed unless you succeed. And so with that being said, we offer one-on-one consultations with us as partners at the firm on your trademark needs. It also includes a national and international search. And Alon brought this up earlier. Your brand, might not be protected based on what we find internationally, right? But we will do the research for you and figure that out. We not only do a search with the USPTO database, we also do a common law search of all 50 states. We also do a search internationally because, again, we are in a global marketplace at this point, especially with online and digital access to buying and selling products and services. If for some reason that search comes back unfavorable, let's say, for example, your brand is being used, and it's registered somewhere, or we think that for a variety of reasons, based on the search that we find, perhaps it's confusingly similar to an existing mark. There could be a variety of issues, but based on our comprehensive search, if it is unfavorable, we will also include one additional search. That is not typical. There's, as you can imagine, because we've explained the exhaustive search that our firm does do to ensure as close as we can that the application will be successful in our diligence. There's a lot of time that's involved with that. And so as this is a Small Business Saturday special we're offering through Cyber Monday is the last day, we will include one additional search iteration if your initial search is unfavorable. So that, again, is maximizing your opportunity to get your brand registered. It also includes a search memo and analysis. We realize that you are experts in what you do when you manage and run your business, and we are experts in what we do, which is supporting small businesses through their intellectual property and business law needs. And so we will provide a comprehensive search memo and analysis of what is the likelihood for your proposed mark to be approved by a USPTO attorney. Further, it includes the application preparation and submission. So once we do the research, we prepare your application and we submit it. on your behalf. It includes unlimited office actions. We talked about that earlier. When you are going through the process, and it can take several months to get the trademark office through for a final answer, and obviously we hope that it's, an approved answer, right? But let's say, for example, you have an adverse office response. And so we basically have to go into paper litigation, for lack of a better term, with the USPTO to represent you. You have unlimited. Let me make sure everybody understands that this special package that we're offering is unlimited office responses. We have never offered that before. We typically do have a fee, a flat fee that we charge because we want to help clients maintain control of budget. There's a flat fee that we typically charge for office action responses. This package includes unlimited responses at no charge. This is how confident we are in our researchability and in our application preparation. So I just want to, put that out there. We have never offered that before. So this is a great time to take advantage of this offer. And lastly, representation for the entire process. So that means that from start to finish, until we get a final answer from the USPTO, you will be represented by an attorney. I want to highlight this because we've had and we've seen people go to LegalZoom. And not to disparage their their product or service, but we're in the USPTO database all the time, and we have seen some of the applications that come in through services like LegalZoom. Some of them are not prepared by attorneys, and some of them have misspellings, and they have office actions. And the thing about it is, you want your application to be right the first time. You don't want any unnecessary delay in the opportunity of your application being approved so that you can use your mark in the marketplace without fear. And so to make sure that we optimize and maximize your opportunity to get your trademark protected and registered, we will represent you throughout the entire process. If you get the Small Business Saturday deal that we're offering until through Cyber Monday. So if you're not ready to, sign up right now, even though I think I'm kind of crazy for even saying this offer verbally, if you are unsure, take today to think about it, take tomorrow to think about it. But the window closes on Monday because it is an insane offer that we're offering. But we're doing this because we're trying to make sure that small businesses have what they need to be successful. And all too often, just like the story we told you earlier about the pizza shop, which they have delicious pizza. So if you're ever on MLK, stop at Blackjack Pizza. But you want to make sure you're protected, right? There was another story that came out recently of a brewery in San Antonio. They had to do a complete rebranding because, when you don't do proper legal consultation and proper research, sometimes you end up having to spend money on costly rebranding because you did not secure the brand. And that's what we're going to help you do, secure the brand. And so, Alon, did you have anything you wanted to add to that on the crazy, crazy offer that we're making today?
Yeah, so I just think that it's really great, a great offer. If you are interested, just submit your contact or request for a contact or consultation through our website. That's elanelawgroup.com. You can fill out the contact information form. We work directly. Okay. We don't have any paralegals or legal assistants doing the work for us. You'll hear directly from either one of us, and we will make sure that your requests or inquiries are answered efficiently as quickly as possible. Just submit that contact through our website, mention Small Business Saturday. Again, as Lorraine mentioned, this offer ends on Monday. So that's midnight on Monday, midnight Tuesday, whatever that is. Yeah. 12 a.m. The offer will end. However, we want to make sure that you are all taken care of. So make sure you submit those contacts. You could even DM us in our social media, and we'll also get back to you as quickly as possible. I would like to also add that Lorraine and I have been working together since law school. We were moot court partners together. We grew a fondness for one another, and we always knew that we wanted to serve our community above all, I'm sorry. And we wanted to make sure that that was translated in our services, in our practice areas, and that we make sure that we help build wealth within our community, that we help build businesses within our community. So Small Business Saturday is just a part of that loving and longing for our community's wealth and legacy. And so we hopefully you take advantage of this opportunity and watch your business grow.
Now, even if you decide that you don't want to take advantage of this deal, you can still call us. It's just that the deal is not going to be the same. So again, it is a limited time special that we are doing, but what will not change year round is that you will work directly with us attorneys. You know, obviously we have a team behind us. We talked about some of our other team members, but we are the face of the firm and we are the workhorses of the firm. And we provide our cell phones to our clients. I'm sure Chriselle could chime in on this. You know, we work directly with our clients and we work relentlessly. So if you have questions, we are accessible. We're here to serve you. And we're here to obviously work diligently towards your ultimate success and your goals. So with that, I want to just, we're going to part here. Chriselle said, yep, that's right.
Oh, thank you, Michelle.
Thank you, Chriselle. Oh, Ms. Vera asked, is it safe to have a small hobby registered? It's definitely safe. In fact, it's irresponsible, I would even say, to not have it registered because, who wants to be in a lawsuit? And as somebody who has been in a civil lawsuit, I can tell you as a plaintiff, yeah, you're bringing forth a claim that has a legitimate legal basis, but the story does not end there. You have to pay for depositions, you have to pay for court filing fees, you have to pay for attorney fees, and a lot of civil attorneys, bill by the hour, and so before you know it, you can end up spending thousands, literally tens of thousands, on litigation for something that could have been avoided by simply registering your trademark. And so it is, to answer Ms. Vera's question, I would even say it is irresponsible to operate without the proper registration because you never know when someone is going to send you a letter in the mail, a cease and desist that you don't want to see. And next thing you know, you're a party to a lawsuit that was unnecessary and completely avoidable.
Mm-hmm.
So
as I mentioned earlier, you can be using that hobby name for years, and everybody knows you by that name for years on end. But then here comes this big company in New York, California, wherever, in China, that now wants to use your name. They love it. It's catchy. They've attached it to everything that they have or everything that they're producing. And now you're boxed out of the market simply because you're a small fish in a big ocean or what have you, right? But as a small fish, we can do small things, take small steps to protect ourselves, and trademark and copyright is one of those things that we can do. So thanks, Mom, for your question. Love you.
Oh, and Melanie says, will do. We already talked. Chriselle, Elaine Law Group is the best. I'm going to stand behind them. Yes. We have Melanie. Love this. Thank you. Ms. Vera, wow, thank you. Thank you, everybody who has liked, commented, and shared to help us get the word out. Again, we're just trying to educate small businesses in our community, whether you decide to hire us or not. It's information that we need in order for our businesses to succeed. And this is just a starting point. So I want to wrap up and say thank you again for joining us.
This is the beginning of a series
Thank
of
you, Alon.
live and Zoom conversations that we're going to continue to have with our community. Please continue to like, share our social media. If you're happy with our services, please make sure that you share and get the word out about what we provide, who we are, what we mean to you and your business. We love that. We, in return, we want to also pub and share the wonderful things that our clients are continuing to do as well. So it is going to be a symbiotic relationship. We're going to love and need one another. That's what we have to do as small businesses. So we are going to continue these conversations, these Zooms and these lives for you and for your benefit. So be on the lookout for those, follow all of our social media, and make sure that you stay tuned.
Thank you, Alon. Thank you again. Our handle on Facebook, Elaine Law Group. Our handle on Twitter, Elaine Law Group. Our IG handle, The Elaine Law Group. Anytime we have specials, anytime we're having workshops, events, we are going to post about it. And Alon is absolutely correct. This is the beginning of a series, an education series for small businesses and creators alike. So thank you again, everybody, for joining us. And I hope you have a wonderful weekend and a great week and continue to slay. Bye.